we're very happy that we succeeded in this mission, because a lot of people have been able to benefit from the OxFirst undertaking and have been able to understand better what the value of intellectual property is, how to extract value from IP, and how to assure also that they're getting the best deal out of the intangible assets. So we worked with large tech companies, we worked with the United Nations, the European Union, the United States. We have been involved in helping policymakers understand the economic relevance of intellectual property. We have been working on litigation, on licensing rates, on FRAND royalty rate determination, meanwhile, several times. We have been the economists in the seminal case in the United Kingdom of Unright Planet versus Huawei when it went to the Supreme Court. So I think all of this pays testimony to the fact that intellectual property is emerging as an asset class and is emerging as an instrument really to systematically extract worth and value from an intangible economy. The motivation for this webinar on licensing intellectual property and valuation came really very much from a discussion we had, several rounds of discussion we have had with market participants, where we have been saying, well, we are in the 21st century. If you looked at how IP was treated in the 1950s, the patent attorneys were basically happy with the value proposition of protecting a patent and saying, well, now you have a patent, dear inventor, dear company, it somehow protects your product, and we kind of, that's about it. And nobody was really aggressively pushing for a systematic market-based economy approach in intellectual property. As a matter of fact, the two paradigms are quite distinct from each other. Patent attorneys protect, company feels kind of safe about it, and God willing, nothing further escalates and we're good to go. In the 21st century, that's just not enough as a pitch. We have figured out that we are pushing markets into areas we couldn't even think before. We are in the era of what's going on with my recording today. So in these new times, we are asking aggressively new questions in IP. We want to understand what's the value of IP. How can I align systematically intellectual property with my business strategy? How does the IP become the business strategy? And oddly enough, the more I've been talking about this, people have been saying, are you becoming a NPE, or are you looking to become a patent assertion entity? And I was very surprised about this, because in no other sector would someone be associated with behavior which is a lot debated about in public by saying I'm doing IP business. And one of the motivations for this webinar today was to correct that misperception and to learn from practitioners as to how they have been treating the question of intellectual property valuation in a time where companies are trying to use market mechanisms and business practices to achieve a whole bunch of goals, including doing good while doing patents. So with that all being said, I'm really curious to hear from such a distinguished audience and distinguished panel from both the United States and Asia as to what the current state of play is.
No, you got it perfectly.
Although the ratings just dropped.
Because the recording was on and off, this meeting is under Chatham House Rules. Not for citation, not for quotations, no name attribution. Thank you. So, great to see you. Great to have you on board. Greg, congratulations for being up at 5 in the morning. You look great for the time.
Yep.
I like the qualifier.
You wake me up at 5 in the morning, I won't look so fit. Yes, maybe let's start with you, Mitsuaki. I mean, being here a practitioner with lots of experience and daily exposure to licensing.
Yes.
How have you looked at the question of valuation?
And before going to the valuation, which I totally agree that it's the most important topic that we should tackle today, but I will share that this IP business equals NPE narrative is out there. But I can also share that it all depends on the expertise and the level of understanding and the maturity of the participants. At IBM, I have the luxury to meet a lot of the companies, both small and big, both new and traditional. depending, it doesn't really matter whether you're new or small or big or large. It's just an experience, and how they view IP as a company is the key in my view. So I think I almost live in a parallel world, because on one end, there are companies that are very, very sophisticated, very experienced, and they would never say that these IP business is an NPE business, because they know as a fact that what they're doing is helping their business and their company. Whereas I would occasionally bump into these companies and folks that just don't have the right understanding or the respect, or maybe they're playing the gamesmanship mode. So they just try to avoid whatever the conversations that I want to have, or I would believe my other patentee friends would like to have. But I think that's where the world that we live in. And I think it is starting to change. But what you're doing, Roya, is very important, because I think it's just a continuous effort for all of us to just continue to understand and respect the value of IP. I'll just stop here, because I can go into the valuation part, but I'll stop here.
Henry, what's your opening statement on that question? What's your key message?
Well, it's thanks for having me. First of all, thank you.
Thank you for joining us.
Yes, I agree with Misaki that it's, there has been always a tension between patent owners and whether we call it willing or unwilling licensees. That patent owners always believe that their patents have a lot of value, but the licensees believe that, well, the value of the accused product is not only attributed to the patent, but also attributed to some other features that are not patent. So there has been, there's no right answer. Maybe you can just fight in court to find great economic experts like Roya to prove that patent is valuable or not. But it's important to find a common ground for licensors to offer a fair royalty rate, and for a licensee to understand patent, and to have a good faith discussion without spending millions and millions of dollars for fighting in courts. So that's just a high level message of command. Yeah.
What about you, Greg?
Yeah, I agree with everything that Mitsuaki and Henri have already said, and how you introduced this Roya. I mean, I think you, especially Roya, have known our approach. We view IP as an instrumental part of the corporate strategy, or where it should be as part of the corporate strategy, with the goal of making it a profit center instead of a cost center, and being proactive. Where, while I'm based in the U.S., a substantial amount of my practice has always been more global, and so seeing IP, and I think we'll touch on this, as more of a global currency. If we can get down to where litigation is just one tool in the toolbox of the whole IP monetization and company growth strategies. What I think also is interesting is that it's been 53 years now since the Georgia Pacific case and the 15-factor test that has dominated, or is still a major consideration point on the U.S. side. But if you take those 15 factors and look at them, so many of them are really, or substantially all of them, are economic and business type driving decisions. And so the seeds of how to develop and make IP portfolios a business tool has existed for a substantially long time, but has been also substantially buried in just the litigation aspects of it. So I think if you start taking a look perhaps also at, again, going back to the history of Georgia Pacific and utilizing those factors on a regular business basis and seeing them for what they are, you can become much more proactive in the licensing and achieving royalty and achieving this type of global marketing positions for your companies, whether they're small startups or more advanced companies like IBM or Panasonic.
Yeah, so I mean, we're seeing here a shift in IP. We're seeing a shift in paradigm where we're moving more and more towards markets for IP, from protection to IP. And a very interesting thought that has recently been born out of Japan is even that what we're really valuing is the experience-based economy. So not even anymore that we are valuing the usage of intellectual property in hardware, in basically what is just plastic, but really in the type of experience that it conveys to consumers. And I wonder, that goes so much together with, I've worked with several banks actually on the question of how to better capture these new trends in the market in terms of, call it responsiveness revolution or revolution in business models, to actually capture markets which we previously couldn't even imagine would be a market. So how do you see these moves going with responsiveness revolution, with an experience-based economy and corresponding valuation trends? Do you see there any changes and need for change in your current activities or in how you look at your job?
Yeah, I'll take the first shot, but in my view, many of my day-to-day counterparts, I believe, aren't there yet. I do agree that this experience-based valuation is something to really worth looking into, but because many of the traditional players and the experienced attorneys or the IP representatives also live in a world where they are used to living in, and of course they also have their audience. So when I would assume that even though they may have some sympathy or understanding to this new approach, it may be difficult for those corporate representatives to get the buy-ins from the corporate executives, especially those that don't do IP.
Mm-hmm. And how have you? Yeah, go ahead.
No, just real quick, and following on that, I think we see the same thing as outside counsel. I mean, we get kind of lucky. We cross between inside outside by betting oftentimes in the client departments and working with their teams on this. But I think you're right. It's a buy-in, and you're starting to see the shift in the fall and getting to something that Roya had said. One of the issues that we run into immediately when companies are looking at some of this changes, are they now going to be viewed effectively as a NPE type of entity, or some sort of, is there going to be just a change in their global perception of them when they start going down these routes? So I think it's going to take a while to change, but at least from what we're seeing is there's a willingness to do that, to start taking these steps and viewing intellectual property more as a global asset base.
Yeah, I'll just add that this experience-based valuation is interesting, but I think what the industry really needs, from my day-to-day experience working with each company, is that, let's face it, no company wants to be the first one, or no company wants to be looked as the first timer. It's a bad thing, right? Generally for the industry, unless you're the first iPhone seller or you're the first Mercedes seller. So this experience-based evaluation really needs the industry whole understanding. Otherwise, I don't think there will be a company that will say, "Hey, I like your idea. Let's just simply do it." No, there's no business executive that will say, "Hey, I support what you're saying," to the IP department director.
So the advantages of it and the new perspectives need to be better understood, and we need more outreach to do before we move into anything experience-based, basically.
I think so. It's the society reception that's really needed. Otherwise, this IP culture is quite slow, right? They're all conservative, and not to, how do you say, because I feel for them, because it's all about them explaining to the corporate executives, and it's a tough job to go to the executives, especially the CFOs of the world, and say, hey, I need this budget because I believe this is good for the company. But that story really needs to be something that's really supported by the society, by the court cases and everything. So it takes time, in my view, for these new experiments to take off.
Yeah, it's education and discussion, and like you're saying, it then translates down to the shareholders also of the large companies, of how are they going to view it. So what's the sales message? This is a selling tactic or a selling move, education and discussion. So maybe, what we're seeing, and maybe that will also help, is like so many of the innovations in Japan, US, and elsewhere, it'll start out with the smaller companies that sort of lead this charge and start making some of the changes, and then the larger corporates will see it, perhaps.
That's true. That's true.
And so when it comes to the role of valuation in licensing, what's been your experience with that question so far? How have you gone along with that? How have you resolved that puzzle? What role has it played in the job?
Yeah, let me take this first one again. I think, again, this varies by company to company. My experience here is that the more experienced the company gets, or the more experience that the negotiation team gets, there is this high tendency for them to really focus on the future of the licensing aspect. They all speak about what's the value for this license for this company's future businesses. And I think the attorneys that support these teams will always look to protect the company's future businesses, so that however the license agreement is drafted, those license agreements will not have a pitfall for that licensee company. Now, again, I have to use the other side of the story, because on the other side, there will be all these people that really focus on the past, infringements, claim charts, and all the construction discussions that will go on and on and on. And ultimately, as Greg said, that eventually takes us to this one toolkit that we all have, which is litigation. So not to say that litigation is bad, but I do think we have a lot of toolkit with us. But for some companies, it's unavoidable for these patentees to go to the last resort.
Yeah, I agree with just real quick, agree with Misaki that it really varies from company to company. And I saw some cases that can take like 8 years to 15 years, even without litigation, for concluding a license agreement. But in those cases, the deal value tends to be a big dollar amount, like 2-digit or 3-digit $1 million. But for small, low-value cases, it can be resolved maybe in just 5 or 6 rounds of phone calls. Yes, it really depends on individual cases.
Yeah, but very much so. And I think Mitsuaki and you, Henri, also hit on something. It's the big stumbling block. We're usually, again, on the side of defending against these types of claims, generally. And when the other side is more interested in the past than they are the future, that becomes a huge stumbling block, especially sometimes given the amount of time before the approaches or what went on, and then the questionability of the IP, oftentimes at stake, and these mountains of claim charts that you get. How does that help a business resolution? And instead, it's pretty much, I think, a turnoff for so many people. It's like, if it's so clean and simple, why do I have thousands and thousands of claim charts? And when I respond, all I get is more claim charts, versus focusing on the future. And when we're able to shift that dynamic to taking a look at the future economic. And yes, we will do something about the past, but let's talk and have the discussion focus going forward, and the forward leads the past. That seems to be a much better way to get to resolution.
Talking about the future, where do you see, because I'll soon stop recording, in a snapshot, each of you, where do you see all of this going in the next 5 years, in the times of the Internet of Things, of artificial intelligence, of next generation technologies? Where do you see this going forward in terms of the valuation of intellectual property and commercializing and managing adequately intellectual property?
I mean, I think the borders are shrinking even more so, and leading towards this like global currency type of concept for IP and patents. I mean, just the evolution in AI alone and all the dynamics there, I think, is just forcing more and more development. It's going to lead most likely to additional law changes between what's covered. Right now, we have the huge gap, as you know, between the US and Europe on what can be covered in AI. And so I think that's going to get, lead to law changes and also concentration points. You'll develop more concentration centers on where IP is developed. But in terms of the marketing, I think the world is shrinking. You're going to have more aggressive actions, perhaps, and also both from new companies on the market that haven't been heard of before to the older line companies stepping up. So I think you're going to see this business model start coalescing in the next, I don't know, I might say the next decade versus 5 years, but I think it's starting, and it's going to get more and more rapidly that way, I think.
Yeah. So in the IoT space, I think I would like to talk a little bit about the standard essential patents that are being increasingly asserted against automotive industry. So maybe you're aware that there are a lot of licensors setting at a much higher royalty rate, but they still believe they're a friend because the automotive, I mean, like for vehicles, incorporating those, like for example, Wi-Fi standard set of patents benefits a lot more than the traditional, like Wi-Fi compliant devices such as smartphone or Wi-Fi routers or modules. But from licensees' perspective, they still believe that, well, the standard set of patents are still the standard set of patents. They are being practiced within just a small chip at like $10 or $15 range. So there has been a big tension between the automotive licensees, prospect licensees, and the set holders. So maybe this is more related to ROS space, because either way could be right in some degree. But I see that a lot of automotive companies are being asserted and sued mainly in the US courts. So maybe, Ray, you can have some insights on, small or piece of standard set of patents, what the incremental value that the patent inventions adds to the end product, which is, let's say, a big luxury cars, for example, having a fantastic infotainment system just because of the small Wi-Fi or even telecommunication functionality.